Reading the Unlawful Internet Gambling Enforcement Act, Regulation GG, from the Reference Guide to Regulatory Compliance. Congress began attempting to regulate Internet gambling activities in the U.S. during the 1990s with the first version of the Unlawful Internet Gambling Enforcement Act, UIGEA, introduced in 1998. The major concerns behind the eventual passage of the UIGEA in 2006 were the incidences of gambling by minors and the potential for fraud in Internet-based casinos. Internet gaming was increasing annually, and by some estimates there were nearly 20 million online bets placed in the U.S. in 2005, the year before the passage of the UIGEA. Congress passed the UIGEA as a late addition to the Safe Port Act in October of 2006. I'm going to start calling it Reg GG, attempts to regulate Internet gambling by blocking the access of unlawful Internet casinos to the U.S. payment system. It is a felony under the law for an entity operating a gaming site to accept funds in connection with unlawful gambling activity. The law also requires financial institutions to take steps to block payments related to unlawful gambling activity. The Federal Reserve Board issued Reg GG in late 2008 to implement sections of the UIGEA related to financial institutions. Its original mandatory compliance date of December 1st, 2009 was delayed to June 1st of 2010. Coverage, designated payment systems. Participants in designated payment systems, including the ACH, automated clearinghouse systems, card systems, check collection systems, and money transmitting businesses, to the extent that they facilitate transfers of funds other than check cashing, currency exchange, or the sale and redemption of monetary instruments, money orders, traveler's checks, etc., and b. they permit transfers at remote locations other than the physical office of the money transmitting business, and lastly, wire transfer systems. Those are the designated payment systems. B. Internet gambling businesses. Business defined includes a business of placing, receiving, or otherwise knowingly transmitting a bet or wager by any means which involves the use of the Internet, but does not include the performance of the customary activities of a financial transaction provider or any interactive computer or telecommunications service. Unlawful Internet gambling defined includes activity of placing, receiving, or otherwise knowingly transmitting a bet or wager involving the use of the Internet where such bet or wager is unlawful under any applicable federal or state law in which the bet or wager is initiated, received, or otherwise made. This does not include any activity that is legal under the Interstate Horse Racing Act of 1978. The routing of electronic data to an intermediate location does not determine the location in which the bet or wager is initiated, received, or made. The following are exempt from the requirement to implement policies and procedures to block illegal transactions. That's 1 through 4. ACH systems, except for financial institutions and third-party processors that are ODFIs, which is originating depository financial institutions, originating the deposits, or RDFIs, receiving the transaction, or gateway operators that receive ACH debits from a foreign sender. 2. Exempt from the requirement to implement policies and procedures to block illegal transactions includes participants in a check collection system, except for the depository bank. 3. Participants in a money transmitting business, except for the operator. And 4. Participants in a wire transfer system, except for the beneficiary bank. E. Commercial customers. Subpart E, that is, are persons who are not consumers that interact with a non-exempt participant in a designated payment system to receive or access payment transaction services through that non-exempt participant. Those are your commercial customers. The requirements under Reg GG is A, Very simply, blocking illegal transactions. B, use of the Fed's policy and procedure examples. And C, due diligence. Subpart E, automated clearinghouse transactions, card systems. F, check collection systems. G, money transmitting businesses. And F, wire transfers. H, wire transfer systems. So those last parts, including designated payment systems and the policies and procedures that have to be in place in order to do what's most required, which is blocking illegal transactions. Going into blocking illegal transactions, the general rule is all non-exempt participants in a payment system must establish policies and procedures reasonably designed to identify and block restricted transactions. This applies to U.S. offices of such participants. Blocking a transaction means to reject it before or during processing. It does not include freezing the transaction or prohibiting subsequent transfers or transactions involving the proceeds or account. Policies and procedures. Financial institutions will be deemed to be in compliance with the blocking requirement if A and B. A, they rely upon and comply with the written policies and procedures of the designated payment system that are reasonably designed to identify and block restricted transactions, provided such policies and procedures comply with this regulation, or B, they otherwise prevent the acceptance of restricted transactions. Third requirement under blocking illegal transactions is policies of payment system operators. Participants in designated payment systems the system may rely on a written statement by the operator of the system that states that the operator has designated or structured the system's policies and procedures to prevent or block prohibited transactions as conclusive evidence of compliance with the regulation unless the participant is notified otherwise by a federal regulatory agency or the FTC. Fourth, protection for parties that block transactions. A person that blocks or prevents a transaction will not be liable to any party for such action if the transaction is a restricted transaction or the person reasonably believes the transaction is restricted, or the person is a participant in a designated payment system and blocks the transaction in reliance on the policies and procedures of the designated payment system in an effort to comply with this regulation. Institutions have a safe harbor if they overblock transactions and are not required to change any policy to allow gambling transactions to occur. 5, 6, and 7 under the blocking illegal transaction general rules. 5. No blocking requirement. No person or designated payment system is required to block any transaction that is excluded from the definition of unlawful internet gambling. 6. Filing SARs. The requirement to file a SAR is not modified by this regulation. And 7. Actual knowledge. An institution has actual knowledge of a transaction or a commercial customer when a particular fact is known or is brought to the attention of either an officer of the institution or an individual of the organization's compliance function with respect to that transaction or customer. Subpart B under the requirements is the use of Fed's policy and procedure examples. Policy and procedure examples referred to in the regulation are non-exclusive, and institutions may establish their own that are tailored to their business. Different policies and procedures may be used for different lines of business and products. C. Due diligence. If a payment system participant exercises due diligence of its commercial accounts, those procedures will be deemed to comply with the regulation if 1, 2, 3, and perhaps more on the following page. 1. They are conducted in the time the account or relationship is established and they are commensurate with the risk of restricted transactions presented by the customer's business. 2. The participant makes a determination based on the procedures regarding the risk the customer presents of engaging in an internet gambling business and determines that either A, the customer presents minimal risk, or B, the participant cannot determine that the customer presents minimal risk and obtains a certification for the customer that it does not engage in an internet gambling business, or C, if the customer does engage in internet gambling, the participant must A, obtain evidence of the customer's legal authority to do so, including a copy of the customer's license expressly authorizing the activity or a legal opinion that demonstrates that the customer does not engage in restricted transactions, and 2, a written commitment from the customer to notify the bank of any changes in its legal authority to engage in its internet gambling business. B, the customer does engage in internet gambling and the participant must obtain a third-party certificate that the customer systems for internet gambling are reasonably designed to ensure that only licensed activity occurs, including age limits and location verification. Further, the participant must notify all of its commercial customers through a commercial account agreement or similar document that restricted transactions are prohibited from being processed through the account. The following entities may be deemed to present a minimal risk of engaging in a internet gambling business, and that's an entity directly supervised by a federal functional regulatory an agency or department of the federal government or any state government. Automated clearing transactions. I laugh because every time I see a misspelling in here. But that's neither here nor there. Automated clearinghouse transactions, subpart D, includes the policies and procedures that are satisfactory for ODFIs, third-party processors, in an ACH debit transaction, RDFIs, and any third-party processor in an ACH credit transaction that are deemed to be in compliance if they, A through C, A, they address methods to conduct due diligence of commercial accounts. B, they address methods to conduct due diligence of existing customers of whom they have actual knowledge that the customer engages in an internet gambling business. And C, they have procedures to be followed if there is actual knowledge that a commercial customer has originated restricted transactions or received restricted transactions as ACH debits or credits. 2, satisfactory procedures must address the circumstances under which the commercial customer should not be allowed to originate ACH debit and credit transactions and circumstances under which the accounts should be closed. And gateway operators under ACH transactions. The policies and procedures of gateway operators and third-party processors that receive instructions to originate an ACH debit directly from a foreign sender are deemed to be in compliance if they include procedures to be followed if the gateway operator has actual knowledge obtained through a government entity that such instruction included restricted transactions, and B, the procedures may address sending notification to the foreign sender in the form in the appendix to the regulation may be used. Card systems, subpart E. Card systems are any system for authorizing, clearing, and settling transactions in which credit cards, debit cards, prepaid cards, or stored value cards are used to purchase goods or services or to obtain a cash advance. Card issuers are any person who issues a credit card, debit card, prepaid card, or stored card with or the agent of any such person. Policies and procedures under card systems. Policies and procedures of card system operators, merchant acquirers, third-party processors, and card issuers will be in compliance if A, they provide for due diligence in establishing commercial accounts, and when the card system operator has actual knowledge that the customer engaged in an internet gambling business. They implement a code system to accompany the authorization request for the transaction that includes the operational functionality to enable the operator or issuer to reasonably identify and deny the transaction if it is restricted, and the system has procedures for ongoing monitoring or testing by the operator to detect potential restricted transaction, including tests to determine that transactions contain correct codes and monitoring payment patterns to detect suspicious payment volumes from merchants. Fourth, the procedures include those to be followed when the participant has actual knowledge that the merchant has received a restricted transaction, such as the circumstances under which the access for the merchant or processor should be denied and circumstances under which the merchant account should be closed. Check collection systems, subpart F. Policies and procedures of a depository bank will be deemed in compliance if they address methods of conducting due diligence of commercial accounts. They address methods for the bank to conduct due diligence when the bank has actual knowledge that existing customers engaging in an internet gambling business, and they include procedures to be followed if the bank has actual knowledge that a commercial customer has deposited checks that are restricted transactions, including the circumstances under which check collection services should be denied and the circumstances under which the account should be closed. The check collection policies and procedures of a bank that receive checks from a foreign banking office are considered to be in compliance if they include procedures to be followed when a bank has actual knowledge obtained from a government entity that a foreign banking office has sent checks to the bank that are restricted transactions. A. The procedures may include sending a notice to the foreign banking office in the form of a notice in the appendix to the regulation, and a foreign banking office includes a non-U.S. office of a financial institution or any non-U.S. office of a foreign bank. Money transmitting businesses, policies and procedures are deemed to be in compliance if they address due diligence methods for establishing commercial accounts, address methods for the operator to conduct due diligence when it has actual knowledge that an existing commercial customer engages in an internet gambling business, and includes procedures regarding ongoing monitoring and testing to detect potential restricted transactions, such as monitoring payment patterns to detect suspicious payment volumes to any recipient, and include procedures when the operator has actual knowledge that a commercial customer has received restricted transaction through the money transmitting business that addresses the circumstances under which transaction should be denied or the account should be closed. Wire transfer system subpart H. Policy and procedures of a beneficiary bank and a wire transfer are deemed to be in compliance if they address methods for conducting due diligence when establishing a commercial account, address methods for the beneficiary bank to conduct due diligence in the event, it says even, the beneficiary bank has actual knowledge that an existing commercial customer engages in a internet gambling business. C. Include procedures to be followed if the beneficiary's bank obtains actual knowledge that a commercial customer has received restricted transactions through the wire transfer system, such as procedures that address wire transfer services that should be denied to commercial customers and when the account should be closed. Regulatory enforcement in this section. The authority for the regulation is exclusively enforced by the federal functional regulators as to the entities that they regulate, and the FTC for all other designated payment systems and participants, and the